All right, it's 1 o'clock, 1 p.m., and I'm going to call the meeting to order. We've got the noticed public meeting of the Child Support Guidelines Committee. It's February 9th, 2018 at 1 p.m. I'm going to call roll. Kathleen Baker.
Present.
Karen Cliff.
Present.
Ellen Crecilius.
Present.
Senator Farley. Assemblyman Fumo. Judge Hoskin.
Here.
Nova Murray.
I'm present by phone.
Assemblyman Pickard.
Here.
Judge Robb. Senator Roberson. Joseph Sanford. Judge Shirley. Justice Stiglitz. Kim Surratt, I'm present. And Don Throne.
I'm present. Also, I believe Judge Shirley is on his way, but said he was might be late.
I'm here.
He didn't press his button. All right, we have 9 present, so we have a quorum. We are now going to go to public comment. Each person who would like to give public comment will have 3 minutes to do so. I will time you. I will be, unfortunately, rude, but we're going to keep the meeting going. So I will cut you off even if you are in mid-sentence. And let's start with if anybody is on the phone that would like to give public comment.
Yeah, I'd like to.
Okay, sir, you've got 3 minutes, and you may begin. And please announce your name, too.
Hi, my name is Michael McDonald. I've been following you guys' meeting pretty steadily. I would like to make some comments. I've been putting together a report to send you guys for and doing research on other countries' guidelines on setting up child support. And I would like you guys to look into how other countries and other states are looking into changing that, or they do either a flat rate for child support, or they're eliminating child support in some instances where both parents are making similar incomes. There's no need for it. If both parents are supportive and loving of their children, you shouldn't pit both parents against each other and make one a slave to the other, making sure that they pay an amount of child support. These laws were enacted in the 1950s when women generally would stay home with the children, men would work, and when there was a separation or divorce, they were still held liable to take care of their children. Nowadays, both parents are actually taking and responsibility of their children, and they're both working and making about the same amount of income. So our current system is currently pitting both these parents and causing needless litigation to the point of where you have a percentage. It makes it worth fighting over children because of money, which is really sad. It's causing so many society's issues. So I see a couple of things on your agenda today is for incarcerated parents. If you guys look into the studies of why some of these parents are getting incarcerated is because of TPOs or protective orders that are put in place as a silver bullet to go and say, oh, this parent's abusive, so that they can foster their claim for primary custody in order to get a percentage of income. So I'd like you guys to do, and I'm also looking into research on this, as it's causing the root of society's issues: anxiety, depression, mental illness, criminal history, drug use, sex trafficking. All this is stemming from that and causing adverse societal issues. So when a parent does get incarcerated, they should automatically their child support should be either taken out or put to a bare minimum. Because as when the parent gets out of jail, they've accrued all this child support that they can't not provide. Then their license is getting taken away. How are they supposed to go look for a job? It's making it very, very difficult. And then you're having all the deadbeat dad situation perpetuated when you have parents that I can't pay child support. I have to go duck the system, or have to go lose my job, and I can't afford this. So I'd like you guys to really consider the effects that child support is having through the Title 4D statutes and the Title 42 Section 666, where they're coming after imprisoning people in a debtor's prison where that was eliminated in 1833. So really look into that, and look into the other other countries are doing it, as they're not having these same issues. About 70%
Okay, thank
of
you, Mr.
litigation isn't there
McDonald.
when you have a set standard of
Mr. McDonald,
joint physical
your time
custody.
is up.
And
Thank you.
Okay. All right, thank you.
Does anybody on the committee have any questions for Mr. McDonald? Hearing none, we appreciate your time today, Mr. McDonald. All right, does anybody else on the phone, is anybody else on the phone that would like to give public comment at this time? Hearing none, is there anybody in Las Vegas that would like to give public comment?
No one at the table.
Okay, thank you. Anybody in Carson City that would like to give public comment? Come on up, sir. You heard the spiel. It'll be 3 minutes. If you could give us your name at the beginning. Go ahead and sit any spot, and there's a button in front of you that you can push that turns on the mic. And that way we can actually hear you, and Vegas can hear you that way too. And if you'll just start with your name, and I will time you after you give us your name.
Hi, everybody. My name is Jimmy Carr. You may know me as James Carr if you've read my written comments that I submitted last week. Those are regarding the potential for a parent with a substantial amount of child custody to incur a child support obligation to a parent with what amounts to visitation due to big differences in parental income. And I urge the committee, if you haven't already looked at those written comments, to look at it. I urge the committee also to go with a plan. Is Judge Robb here? No. I just want to know if she's here. But I like her plan, but there is some problems I notice with it, particularly in situations of high income. In case my Walmart and JCPenney designer wear did not give me away, I'm a parent that you probably consider to have high income, and I noticed some problems, particularly around the brackets that she has. For example, a person making $99,000 would have a higher child support obligation than a person making $100,000 because of the 18% and 14% thing. So instead, what I advise the committee to do is don't define a parent as high income. Define a certain portion of that parent's income over a certain level as high income. I gave some written notes to the secretary, and it discusses this in more detail. So what I suggest is cutting it off about $80,000. Say anything below $80,000 for one kid, you're going to be on the hook for 18%. Anything $80,001 and above, 5%. And that actually results in awards very similar to Judge Robb's plan. However, it avoids the weird situations at the brackets on her plan. So don't define a parent as high income. Define a portion of that parent's income as high income, and take child support at a lower rate. And that accomplishes the goal of, or what the committee has previously recognized, in that there's parents with higher income spend a lot smaller portion of that income on the children as their income increases. So I put this in writing and gave it to the secretary. I urge you to take a look at that. Just to give one quick example, a parent making $100,000 per year under Judge Robb's plan would have an obligation of $1,167, which is 14% per month. And a parent under my plan, where you cut it off at $80,000 and then anything above that is high income, would have an obligation of $1,283. So they're actually pretty similar, but it avoids those weird situations at $100,000 and $150,000 with the 14% and 10% thing. Since I have time, I'll also mention I urge the committee to avoid a 1.5 multiplier or any other multiplier in situations of joint custody, because that just serves to enrich people, and it also could result in a parent having a higher obligation under a joint custody plan than they would if they just had visitation.
Okay, thank you, sir. It's been 3 minutes. If you'll stay there for a moment, let's ask, does anybody on the committee have any questions for Mr. Carr? Hearing none. Mr. Carr, I want to clarify. You submitted something to us in writing on February 3rd, but what you submitted today was in addition to that, correct?
Correct. It kind of builds on that. The comments that I submitted on February 3rd related to what I think would be improper awards of child support to a parent with weekend visitation.
Okay, and then what you submitted today is more along the lines of what you were just talking about changing that dollar amount for when you calculate high income.
Correct. If the committee were to
Okay.
go with Judge Robb's plan, then I would suggest those changes.
Okay, and just for clarification, it's the whole committee's plan, she's just putting the document together, but that's kind of our working,
Okay.
what we're working off of, but it's not a done deal, so we appreciate your time. Any additional questions for Mr. Carr? All right, hearing
No
none,
question,
thank you. Oh,
Madam Chair, but
yes.
this is Bridget Robb. I'm here now.
okay. Thank you, Judge. Do you have any questions for Mr. Carr?
I do not, but thank you.
Okay, thank you. Thank you, sir.
Thank you.
And I want the record to reflect that Judge Robb's now with us on the phone, and Justice Stiglitz came in after we did roll call also. All right, is there anybody else in any of the locations or on the phone that would like to give public comment at this time? Okay, hearing none, we're going to close that agenda item and move on to the next. And that would be approval of meeting minutes from January 17th, 2018. Do I have a motion?
I almost said move to admit. I've been in trial all week. Move to adopt them.
All right. All in favor, say aye.
Aye.
Opposed, say nay. Motion carries. All right, we're going to close agenda item number 3 and move on to all of the agenda items number 4. And as we have done in prior agendas, number 4 is really just is a placeholder to describe all the subcategories under it on the agenda regarding the Nevada Child Support Enforcement Program overview review that Jane Venord performed on our behalf. Let's move on to 4A, and let's discuss the recommendations as to the proposed child support language for a formula for child support based on the exhibit provided by Judge Robb. I know there's some other elements on there that are individually listed on the agenda, so if we do have a separate agenda item for those specific items, we'll talk about it. But let's open the floor right now to discuss the overall formula that we have in this document. Anyone? Anyone? Are we prepared today?
Judge Hoskin.
Do you want me to jump right
jumping
into
in.
specific items on the agenda? Yes, Judge.
Well, yeah, if you want to go ahead. No, I just, you were talking about formula, and I don't know that we've gone to formula. I know Judge Robb kind of threw in some numbers, and if I remember correctly, she's disavowed any thought process in that, and she's hoping that we're going to take a look at it. But there were a couple of new additions that we submitted that looks like they've been incorporated in, so we can certainly discuss those if you see the need.
I think right now is the time to do that, although some of them are very specific to childcare and health, which are really under separate agenda items. But based on the public comment that we received from Mr. Carr, I wouldn't mind us opening a discussion right now about the calculation itself and the high income amounts, just to have a discussion about that. Does anybody have any comments to add? Come on, committee.
Keith Picker for the record. I'll jump in.
All right, thank you, Mr. Pitt.
I certainly understand Mr. Carr's comments in the letter. I think logically it makes some sense that child support would somehow track the timeshare. I just see two practical problems with it as a practitioner in this area. I don't know how we would create a calculation that would be understandable by anyone who wanted to do this on their own. I think it would take a fairly complex algorithm to do that sort of thing. Otherwise, we end up with a tier-type situation that we're trying to get away from. So I see that as a practical. I'm not saying that that's reason necessarily to dismiss this idea. I'm just saying I don't know how to approach that. And then the other thing will be, as we, are getting close to the end of our discussions. I think we may be past that point. I think we're all getting to the point where we need to start making some concrete decisions, and that would kind of reopen what we've already tried to nail down. So I certainly think that in the next iteration, because as we discussed last time, we've got a situation where we have to come up with something by June. Statutorily, we're mandated to have these things in place. And so with the the Child Custody Committee that's moving forward, and the discussion we had last time about the possibility of them going to a non-labeled custodial award, and how we had pretty much decided, I think, at least I felt that there was a consensus that we needed to move forward with what we have now, and then in the next iteration of our review, if the legislature does remove those labels, then we would address that then. I think this would be a perfect thing to insert in that discussion. So even though I know Mr. Carr would like to see some of this addressed, if not all of it now, I think from a practical standpoint it would make more sense to do that in the next iteration, and we need to come to some consensus on the concrete steps at this point so we can actually put them into place over the next, I think we have 4 meetings left. So those are just my remarks. Thank you.
Okay, do we have additional comments from anybody on the committee?
Judge Hoskin again.
Yes, Judge.
It's my recollection, and it has been a while since we've talked about this, but I know that we keep bouncing back to is the percentages that we're looking at, the current percentages is broken. My recollection from the report was that we were pretty consistent, notwithstanding the whatever effort was put into coming up with the 18, 25, 29 percentages. And we've left, and I went back and looked at what Judge Robb has so kindly compiled, and she's got those numbers as placeholders. But as we sit here today and all the meetings we've had, I don't believe, and I'm certainly willing to accept comments from other members of the commission, I don't know that we've had anything presented to us to indicate that our percentages are off. So for moving forward, given the fact we haven't received anything to the contrary, it might be advisable for us to maintain those, at least for the low income that we've talked about, and I don't know that we're getting into high income just yet, but for the low income, to perhaps maintain what we've had in the state for some time under those percentages. And if we've received contrary information that we're off, I'd like to hear it. I just don't recall it from any of our meetings.
Keith Pickard for the record, if I could just piggyback on that. It seems to me in the report, and I'm looking at the charts found on page 30 of the report, where we were looking at the stair-stepped tiers and where they fell into the child rearing expenditures. They were, even though it was kind of awkward, they still fell within the appropriate range or the recommended range. And so I tend to agree. I think even if someone were to present us with a different set of percentages, I think they would have to show that they do a better job of putting us in the proper range. And frankly, according to the reports, they're already there. So I would suggest, as a practical matter, we adopt the percentages in order to move forward, having seen no contrary information. Although I do have one question, and that is they have historically been 1725.
18.
Are they 18 and 25? Okay, so then I've got it backwards in my head. All right, never mind. So that would be my suggestion.
It's Kathleen Baker
This is
for the
Dawn
record.
Throne.
Go ahead, Dawn.
Sorry. I do have a problem because we're supposed to be tying this to the cost of child rearing. And I'm having a trouble getting a jump from what the data is about rearing a child in a two-parent home to now rearing in two separate homes, and how do we divide the cost of that between the two separate parents, and coming up with 18%. And then I'm afraid that 18% for one child is going to be too much child support when, again, not the right size order, not collectible, when we add the medical support and then add the child care too, it could be substantially higher than it should be.
I'll
Can I
piggyback
ask
on
a
that,
question?
Kath.
This is Bridget Robb.
Oh, go ahead,
Can I
Judge.
ask a question of Ms. Baker?
Certainly, Your Honor.
Ms. Baker, were you thinking about lower income parties because the schedule isn't attached to the language that was just sent out, but there is a provision for parties with lower income as well as parties with higher income? This would deal with mainly the mid-income, and so I'm not sure that we would have quite the problem that you are identifying.
And Your Honor, it's amazing because you did read my mind. I hadn't identified it yet, but you just did. So that sounds appropriate to get the mid-range folks. But I do want to make certain we have that self-support reserve or at least have some different formulas for lower income folks.
And if you look, it's, I think now subsection K of this language does deal with low income payer. And there was a chart that was attached the last time, which I neglected to attach this time, that kind of deals with, it's an idea of how to deal with the low income payer. Because I understand your concern. So there is some built-in self-reserve there for those persons, although there's still going to be a minimum amount of child support that they would have to pay.
And Your Honor, I
It's just
actually
not
have a
going to
copy
be
of that
a-
chart in front of me. It was actually attached, it's page 38 of the meeting minutes for December 13th, which starts with an income up to $754, the percentage being 11.88, goes up to a monthly income of $1,508 with the percentage at that point going to 18%. And I think that does address
That is what I'm referencing. Thank you.
This is Kim Surratt for the record. I also want to clarify a little bit too, because when we've got two conversations going. We've got the percentages that we've got in our exhibit that we're working off of, but then the comments kept going back to our percentages in Nevada haven't been shown to be wrong, but we have to remember our percentages were based on there being income brackets and caps. So they technically were wrong because you did the percentage and then you had to jump back down and cap them based on the caps. And so, you know, by hook or crook, yeah, that's based on the old model. The report said we were landing somewhat at reasonable amounts, but we were landing at reasonable amounts with 4D cases without private data. So I think, you know, we talked about sticking these Wisconsin percentages in here. And then I think what we were all waiting to see was take it through all these scenarios and do the math and take some different example cases and see where the math falls and see if it's reasonable or not. And I'm still concerned, we can do the argument about meetings, but I can set more meetings, don't worry. So number of meetings is no longer an excuse on this committee. But, you know, without really knowing how we're going to deal with shared parenting, the split parenting, serial parenting, all these different scenarios, could I vote on these percentages being exact today without being able to take all my different scenarios and work through the formulas and see how they land? I think we could still easily decide they need to be adjusted a little bit down the road. And I'm with Dawn that when you do the math, do you necessarily hit right on the USDA numbers for the cost of rearing a child? I don't know. It depends on the scenarios, but I don't know if we're all the way there yet. but we've not really had, we put all this together out of the Wisconsin model without having a real good discussion about what to do with it now, and I think that's where we're at. Any other comments from the committee?
This is Judge Hoskin again. I don't know that I disagree with you on anything that you just said. In fact, I think that's what we've been doing is waiting to see, okay, are we going to add in childcare? Are we going to add in health insurance? And when we do, how is that going to adjust the percentages to keep us within that range? And I think that's why we keep putting off finalizing those percentages, is because we don't have all the information yet. So are we premature in finalizing those percentages until we actually have a great handle on what the effect of childcare and health care is going to have on that total number, to make sure we're not in a order that's unreasonable? And I hate to defer it out further, because I'm with Assemblyman Pickard. I want to see some progress, but I also don't want to make progress for the sake of progress and come up with something that's going to be a problem. Certainly if we can review it down the road, I'm okay with that, as long as that's the understanding. But I still don't think we've done all the math that we need to do yet.
My proposal for, as far as the agenda goes, is that we table this for right now. We talk about some of the other items we have on the agenda today and some of the other language that we've brought forward, and with the hope of circling back to that at the end of this meeting. But I think we need to have some of the other discussions first. Is there a general agreement to that? Hearing none, I'm going to say that's a yes. All right, let's table agenda 4A for right now. And let's move on to 4B, discussion and recommendations based on proposed language on how to treat incarcerated parents or a parent recently released from prison. The incarceration language, based on the not last meeting, but a couple of meetings ago, last time we talked about incarceration, has been provided with some edits. And I'm going to start with, well, I'm going to call you out because I think you might want to talk first. Ms. Cliff, do you want to talk?
Sorry, I'm just trying to gather my materials.
Sorry, I just called you out on it. I just assumed that because you missed that one meeting where we made some agreements on some edits to this, and I thought you might want to give some input. If you're not ready, we can take it from the rest of the committee first.
I'm happy to defer to the rest of the committee first.
All right, great. Anybody have any comments on the language that was provided on incarceration? Yeah, why doesn't everybody tell me if they've read it yet or not? If not, I'll give you a moment to read it. How about that?
And this is Kathleen Baker, and I picked these up when I walked in the room, so I have not had a chance to look at the incarceration or the medical support language or Judge Rob's language.
Okay, everybody take a moment to read the incarceration language, and then we'll move on to the other stuff. Yeah, we need to put it on the record. The question was this copied from another state? Originally, we took language from California, but then it was edited based on motions and votes at a subsequent meeting.
I'm just wondering, this is Ellen Criselius, if this Division of Juvenile Facilities and Department of Corrections is correct, because my understanding is it's in the juvenile facilities in the state are operated by the Division of Child and Family Services and the Department of Health and Human Services.
Oh, it probably is not correct.
Okay.
So that would be something to edit, yes.
Yes,
I
so-
didn't put much thought into that part of it because I obviously don't do criminal law either.
So the
All right,
Division of
so-
Child and Family Services operates the juvenile facilities.
Is it still called family or juvenile facilities in Nevada? Is that the correct word?
I'm not sure.
I'm not sure either. I don't do criminal, so I don't have a clue on that one. Okay. Judge? Yeah. Judge Shirley, go ahead.
I would just say a facility operated by the Division of Child and Family Services.
Okay, thank you.
Karen Cliff from the Clark County District Attorney's Office. Do we want to add federal prison, or is that just in the not limited to?
Yeah, I think but not limited to is meant to cover everything, but I don't know that it hurts. What's everybody's thoughts on that?
I was hoping for like maybe state / federal prison, but I'm open to the not limited to part too.
I like adding it in. It just makes it that much clearer.
Okay. Keep working on edits, and then what we'll do is I'll just kind of compile it into one motion at the end, if that works for everybody.
Madam Chair, Judge Hoskin, I know that in one part of our discussion on incarcerated, we were talking about a certain period of time that they would be incarcerated before it would kick in. We bounced between 90 and 180 days, as my notes indicated, and I'm not seeing numbers anywhere, so I don't know if that didn't make it through or we've decided that it's immediately upon incarceration. I just recall that we debated 90 and 180 days a few meetings ago.
We did, and it may be just that because the language we had in front of us, I think maybe we just didn't incorporate. We did talk about days. You're right.
And additionally, while we're talking about edits, I would suggest that beginning at subsection C through what looks like I should be separated out into not separated out, but indented in rather than ongoing subsections. It's all about incarceration. It should be under the same outline number. I'm not quite sure what those editing terms are, but
Okay, which one again?
I believe when we start talking about incarceration is subsection C in our working draft, and it looks like, at least from what I can tell in skimming it, it goes through I, when all of that probably should be under C, and J should be D. Does that make sense?
Yes.
Because it feels
does.
like it's...
I was struggling
it's
with
not-
that, Your Honor.
Okay. I just...
I think what we should probably do is have one section, and I'll reorganize this, but one section that is definitional, and then move down into the substantive portion.
Yeah, and it may be that when we work through these kinds of things, we just try and get all the information in, and then we pretty it up at the end. But just for, while we're talking about edits, that I thought I would throw that in.
Okay.
Madam Chair, may I ask a question?
Yes, ma'am.
All right, Lydia Stivlich for the record. Two things. One, so under the incarceration proposal at 4B, during the period of incarceration, would even a minimum amount of support accrue? So would they continue to accrue the support obligation, whether or not they had an obligation to pay it or is found to be in arrearages? That's one question. And then two, how's this going to work practically? So the person gets incarcerated, and how's that going to get brought to the attention of the court? Do they have to petition? Does it happen when they get out, when an adverse action happens? I mean, who is going to manage this section to effectuate its perceived purpose?
And I'll answer real quick, and then I think Ms. Baker and Ms. Cliff can answer better. There's two different types of cases, obviously, that we're dealing with this, because we're talking about under 4, we're talking about 4D cases. And I know Ms. Cliff has testified before in front of this committee about how their systems are coordinated together with the prison system, and they know when somebody's incarcerated. And they've already got a system in place for the change of child support. We did have an operation of law language in this before that we voted to remove, that it would be by operation of law, so that it would have to be a motion and notice brought to the court so that it could actually be considered. And one of the things, obviously, to be considered is some of this language in here about whether or not, just because you're incarcerated, what the federal law requires is that we cannot impute income, meaning you can't say as punishment because you're in prison and you could be working a job but you put yourself in prison, that in itself is imputation of income. So the federal language requires us to very specifically have that language, that cannot be imputation. But if somebody still has the ability to pay, so some of the communications we've had is they're still receiving income, have a business that's still operating or something out there, some means of still paying child support, that's part of the reason we don't want it to just automatically disappear. Can you add anything that I didn't cover?
So the
Ms.
other thing
Baker?
the regulations talk about is they use 180 days. And I think one of the things to look at is the fact that somebody's incarcerated, they may be incarcerated for a day, they may be incarcerated for a month, they may be incarcerated for 10 years. But I think in the child support arena, we're really looking for a substantial change that's going to last for a period of time. We don't want to be bouncing back to court. So I think 90 or 180 days, looking at they're going to continue incarceration. Our office doesn't know about everybody that's incarcerated, but as soon as we do, we look to file motions if they look like they're going to be incarcerated for a while. I think the more difficult things that I've looked at is I'll know that a parent has been arrested and they're incarcerated and they're pending charges, and we don't even know when they're going to trial and what the outcome of that trial is going to be. If they look like they're going to be there for a while, then I think we need to have the ability for them to come and make that motion to the court and plead their case, and we certainly do that at the District Attorney's Office in Washoe County. And then the other thing, I think, in terms of a minimum amount, I'm not certain that we're going to be able to skirt around the Fed's requirement that child support obligations be based on the ability to pay. And unless we have some source of income for somebody, then I don't know that we can set a minimum amount because they don't have the ability to pay even the minimum.
Ms. Cliff?
Karen, Clark County District Attorney's Office. In our county, we do interface with all the statewide facilities. That includes the prisons as well as the correctional facilities. So we understand when they are in, for example, Southern Desert Correctional Center, Florence, McClure, the various conservation camps to include 3 Lakes, in case we did want to expand that to include correctional centers or leave it as the unlimited 2 box. My feeling is 0 is the appropriate order. That would be our default. That's what it is now based upon ability to pay. It's in line, I think, with Jane Venor's position as well. If we look at page 85 of her report where she insists that we address this issue, she even states in her report, again, this is page 85, even the minimum orders are beyond what an incarcerated parent can pay. So in Clark County, we modify it. We set it at 0 unless there's testimony to the contrary, in which case we'll place that matter on calendar to get testimony on whether the respondent's working. Generally, the respondents are not working. They have prison industry wages. So generally, if an incarcerated individual qualifies...
Hold on just a second,
and
Ms.
they're
Cliff.
able-
If you are on the phone and you are listening to our hearing, we can hear everything in your background noise. So if you could please mute your phone, that would be beneficial to us. Thank you. Go ahead, Ms. Cliff, sorry.
If an incarcerated individual has the privilege of getting a prison industry job, the hourly rate is minimal, And we have a statute already that governs the priority of those monies that are earned, and that's under NRS 209.463, and that's deductions from wages earned by an offender during incarceration. And we know this because we were trying to pursue these funds, and we've ran into some glitches. But that we'll leave it at that. But that determines the priority of wages. So that's not income we could even go after if we wanted to. Now, in terms of a trust or some other source of revenue they may have, in terms of money that's placed maybe in their account, there's several different types of accounts within the prison system. Some of them you can attach, some of them you cannot. Some of them are for hygiene products. Some of them are to, reimburse a victim. It gets complicated. So generally, the support is set at 0, absent testimony to the contrary. It's very easy to do. You have language in the order that states it goes to 0 upon incarceration, and you leave it at that. Internally, our system's able to manage that. It does it successfully now, and there's no need for a hearing unless somebody disagrees. Under the new EDCR, there's non-hearing motions. So you're filing the motion, you're not requesting a hearing, and the court's not burdened with any of these changes. In terms of the 180 days, under the new federal rules, that's section 303.8, that's in our handout. We are required as a 4D agency within 15 days upon learning of an individual's incarceration to notify the parties that they're entitled to a modification. So it's not so much whether we have the ability to do it, we have to do it under the new federal rules.
Keith Pickard for the record.
Hold on, Mr. Pickard. Justice Stiglitz is next, and then you can go.
Okay.
Cuts. I think I was first. Okay, so just quick follow-up on the 209 funds and the priority. If that's a complete creature of statute, should we be looking, that be one of the statutes we should be addressing on whether children should be in that priority or a higher priority, even if they're limited funds for that?
I don't believe we have I don't believe this committee is permitted to address NRS 209.463, but I'll defer to the chair.
I agree. That's outside of what we are mandated by the legislature to deal with. Unfortunately, just the calculation of child support is what we're dealing with.
Non-binding recommendation.
Exactly. So yes, I agree. That's outside of our purview. Mr. Pickard? Assemblyman Pickard.
And I am certainly happy to defer to my senior. In any event, let me respond first to the idea that I think we can make recommendations, and maybe we do that informally. We've got a number of legislators on the committee, and maybe we can just internally circulate ideas. I think it's probably worthy of keeping a list of some of these things. I've got a few notes already on some legislation we should consider, and I am bringing at least one bill where this might help, or that we may be able to address the other legislative things that occur outside of the jurisdiction of the committee. So that's just an aside. My question, though, with respect to the automatic zero order, I understand the practical aspects of that, but I'm just wondering, would it be impossible to either allow the 4D program to do what they do, but have a different rule in place for non-4D programs, or would it overburden the system if we moved it to the minimum order and let them come forward if they cannot? The reason being, I naturally resist the idea that the spouse, or more importantly, the child who had no part in the parent's decision to do something that got him or her incarcerated would automatically go to zero. We have established in the statute that the public policy of the state is that all parents owe their children an obligation to support them. And so it seems that if we automatically go to a zero order, that's kind of cross purposes here. That's contrary to the stated policy. And I think if we were to go to a minimum order, absent testimony, and then give the people an opportunity to ask for a zero, as I understand the statute is today, I think that's more aligned with the public policy. So the question is that practically possible?
And I'll add, this is Kim Surratt for the record. Ms. Cliff, this is one of those examples of something that we had a motion and an actual vote on. I'm giving some leeway to it because you weren't at that meeting in order to entertain it some, but the very specific motion was based on public comment we received that day about incarceration that was, in my opinion, relatively heavy and played to a lot of us as to why we need to consider whether or not it was going to go to a minimum order like everybody else in the state has to pay versus zero. I think Mr. Pickard's question is fair, which is, can we separate out 4D if it's really going to be a problem for 4D to go to minimum orders versus zero orders? Is it practical to separate that out from the private cases and have the two different obligations or two different duties? I get concerned that that's different treatment for different classes of people, and one of those classes is one that's committed a crime that's getting a better treatment than those who did not, who have to pay the minimum and don't get zero orders, are never allowed to have a zero order. So I think this, I know during our hearing we also had testimony from Mr. Stanford and Ms. Baker that their systems also, they're able to look and see statewide when somebody has been in prison. So I know that it's somewhat consistent, but if we can hear from Ms. Baker, we don't have Mr. Sanford here with us today, but Ms. Baker and Ms. Cliff some more about this. We'll see if we can iron this out a little bit.
I'm sorry, this is Karen from Clark County DAs. Just a question. When we talk about the minimum, are we referring to the low-income appendix where it could go below the 100? Okay, so we're not even necessarily saying it would be 100, just whatever the agreement might be on the low income
Right, because
appendix?
this committee voted to get rid of the $100 per child per order minimums because
Okay.
we won't have that anymore once we put our system in
Okay.
place for low income reserves.
Okay. So in the 4D program, the case remains open during the incarceration unless the duration of the, and this is part of the federal closure rules, unless the duration of the incarceration is beyond the child's majority. So while I wasn't present during some of that testimony, and I do empathize with their situation, the reality of the 4D program is you could establish a case because the child is receiving state TANF and they are 1 year old, and this individual is incarcerated for 15 years, and that's 15 years of a child support obligation that's accruing at $80 or $100 a month. And as Jane Venor points out in her report, now you have an individual that has no ability to pay, and under the federal rules, irrespective of all of that testimony, the orders need to be set based upon ability to pay. If an individual's gross monthly income is zero, how do you get to $100? And let's presume you do. You have 15 years of that obligation accruing while it's open in the 4D program, and now this individual is reintegrating into society with an enormous arrears debt. And so I do appreciate all that testimony, but I do want to point out what Jane Venor is pointing out to all of us to consider, because $100, that's status quo. Up until recently when we started modifying these orders based upon ability to pay. So I see both sides of it, but thank you.
Madam Chair, Keith Pickard for the record.
Yes, sir.
I certainly understand the practical aspect of that. I think part of my thinking is that Ms. Venor does not reside in Nevada, doesn't answer to Nevada voters, and those of us that are electeds do. and by extension, so do the rest of the committee. Ultimately, I think that I have no problem with the notion that a person who's incarcerated for 15 years for something serious and you know they have no ability to pay. I think that that's a practical reality that the court, or I'm sorry, that the law needs to take recognition of. But by the same token, I would put it on their shoulders to make the case why they should not, upon release, meet the obligation that they started when they conceived the child. So I'm sympathetic to the practical realities, but this is one of those consequences in my mind that we have to consider. And so that's why I would rather go to the minimum, whatever that minimum is. And I agree it would be the minimum on the low-income table. But at the end of the day, I think a zero is going automatically to a zero when no one else gets that opportunity is terrible optics, and ultimately is contrary to the stated policy of the state.
Mr. Pickard, I'd also add, so looking at the Federal Register at page 93527, where there is comments about whether or not their rule, the rule really is just specific to you cannot impute income to somebody that's in prison. You can't use it as a punishment. And there is a comment that says the rule does not provide special treatment for incarcerated parents. Rather, it requires application of federal review and adjustment requirements, including that orders be reviewed and adjusted upward or downward in all cases upon a showing of any substantial change in circumstances, including a substantial change in circumstances due to unemployment or incarceration. In what we had discussed in when we made this motion to eliminate the automatic $0 orders, was that what we were looking for is the ability to have a hearing so that that adjustment could be made, versus language that says automatically in all instances it's immediately $0. Because that's not what the feds are saying in here. They're saying we can adjust up or down, but it's not saying we have to automatically go to zero. I get zero's easy, and when you do that across the board, but I agree the optics are bad, and I think based on the public comment that we received at that time, that's why we shifted gears on it, and our opinion on it. Other opinion or comments? Ms. Baker?
Kathleen Baker for the record. I know the optics are bad as well. It's a hard thing for me to swallow, but I think one of the main distinctions for somebody who's incarcerated versus somebody who is not incarcerated and is unemployed is that the person who's unemployed has their freedom and they can go and they can try to find work and they can find a job and they can meet their child support obligation. Somebody who's incarcerated doesn't have that option. Somewhere there's got to be a middle ground, but I just don't, I mean, with the ability to pay a component of the federal requirements, I think we're going to have to come up with something that's less than $100 a month.
But we're
Madam
no
Chair.
longer just set at $100 a month. I mean, we got away from that. We did make that motion, and that's still standing. And I'd say for this to go back to being $0 orders, it would take another motion, because we did have a motion to make that change within this language. But we do have less than, we're not $100 per child per order any longer, which was part of the unreasonable part of it.
And this is Kathleen Baker again. I agree that we should actually have motions and that should be considered by the court to determine whether or not it's appropriate in this particular instance to set it at zero or set it at another figure. I'm not in support of doing an automatic operation of law setting it at zero.
This is Karen Cliff from the Clark County District Attorney's Office. I think we also have to be mindful in the 4D program. We're not just talking about one child. I would venture to say most of these cases have more than one child, so you start looking at the minimum, $400 or $500 a month is what this non-custodial parent is accruing while they're in prison. So that just adds another little twist, and I understand you've already made your decision, but I just think there's a lot of things to consider.
Madam Chair.
Yes, sir.
To Judge Hoskin again, to deal with Ms. Baker's concern, certainly the court has the ability to impute income on those circumstances where somebody's willfully unemployed or underemployed, and I don't know that we've eliminated that as part of our discussion. But as Assemblyman Pickard said, we can't lose sight of the other side of this equation, and that is the child and the stated policy in Nevada. I guess I'm a little surprised that the DA's office is going to a zero number, because I don't know that I can go to a zero number under the law as it currently exists, given the statutory minimums and the findings that need to be had. Given the fact that we've already, I think, passed through this tunnel, I'm not sure we're gaining any ground by covering it again. So if there's an issue with regard to the language as it had been proposed in what Judge Robb's compiled, then I think we probably need to focus on that rather than rehashing old ground. Just my suggestion.
Agreed. Of course, the amendments that were made based on the motion we had are in this language, this incarceration language, so we do have to get to final language on it. And at the moment, we have, I was looking at what happened to the 180 days. It was part of that operation of law language before, which is why it disappeared in here. But if we are going to, but we didn't necessarily agree to get rid of the 180 days. So the question is, we've got to get to what our motion is right now in terms of this final language. And I would break it into pieces. And first I'd say, I'll make a motion to do the first change we talked about, which is to add state and federal prison to the definition of incarcerated or involuntary institutionalized, and change it from Division of Juvenile Facilities to Division of Child and Family Services. Do I have a second on that motion?
You have a second?
Okay, second from Judge Shirley. All in favor say aye.
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 Opposed say nay. Motion passes. The next motion I would make is to incorporate the number of days of incarceration into the definition of incarcerated or involuntary institutionalized individuals based on prior meeting minutes of utilizing the 180 days, as it has to exceed 180 days to fit within that definition. Do I have a motion for that?
So moved.
So moved.
Second, we'll make Assemblyman Pickard your second to the judge. All in favor say aye.
Happy to do so.
Aye.
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 All, those opposed say nay, sorry. Okay, motion passes. All right, if any other motions are needed for changes to this, you're welcome to make a motion at this time, or we will move on to the next agenda item. Hearing none, that language will stand as it is written right now with those edits, and I will make those edits to get it incorporated into our main working document that we're working off of. Let's move on to agenda item number 4C. Discussion and recommendations as to the definition of child support for purposes of calculating child support. And Judge Hoskin, I believe you had some edits that you made from the last meeting, correct?
That's correct. And although I did send those to Judge Robb, I didn't see that they made their way into the working draft. Judge Robb, am I missing it somewhere?
Judge Hoskin, the gross income, is that what we're talking about?
No, the other one. I sent it a few weeks before the gross income. It was the child support definition edits from last meeting.
My fault, it did not make it in.
Okay, that's what I thought, but I thought maybe I was missing something. So we will table 4C for right now because that didn't make it in, and we will discuss it at the next meeting. Agenda item
Judge
number...
Robb, do you need me to
It's
resend
okay.
that?
Go ahead,
Judge
Judge.
Robb, do you need me to resend the...
No, I had collected them all and thought I had gone back to get all of them and just missed that one. I apologize.
Okay. All right, not a problem.
All right, while we're at it, let's do medical support, which is, Let's skip to agenda item number 4H, discussion and recommendations regarding revised proposed language for calculation of child support with health care expenses. And we had edits that were made to this based on our last meeting. Does anybody need time to read that? Yes. Okay. Hearing comments that we do need time to read it, I'll give you a moment to read it right now.
This is Keith Pickard for the record. Judge Rob, can you tell us what changed from the last time? May make it easier than trying to make the comparison.
Actually, if I could defer to Ms. Roan, this is her language. I just dropped it into the master document.
Ms. Throne?
There were very little changes. One was changing the other forms of medical coverage. When did we change
Medical,
it?
dental, and vision instead of just healthcare.
Right, and then what is available through the state, we changed the word for that.
Oh, okay. Yeah, it's just, I think it was
This is Kathleen Baker for the record. Maybe I'm not reading this right, but it looks like we're trying to include the cost for the health insurance premium, but also for payment of any expenses that are not covered by insurance. I don't know how we could possibly figure out what those expenses are going to be because they're going to vary from family to family pretty substantially. So it seems to me that when we're looking at the obligation for support, we should be talking about the payment of the insurance premium being included in it, but not necessarily any unreimbursed medical expenses.
Good call. That's what happens when you start changing the formula and getting away from deviations. I hadn't thought about it that way. Because everything else would be split upon incurring it. Correct. Yes. You're right. So it's the base premium only that should be part of this upfront calculation, and then the parties are just obligated to go 50% after that. Yes.
I'm sorry, I'm not, where is Ms. Baker looking that she's seeing that? Because I'm not seeing
So
that.
if you look at C and then 1, and it defines medical support, that includes cost of coverage, and then the second to the last line, deductible, and the payment of all necessary medical, vision, and dental expenses that are not covered by insurance. I don't even know that we can even do the co-payment or deductible on that. I think it needs to be limited to the insurance premium.
Oh, I see, okay, I see. So you're proposing that we eliminate after the and the payment of all necessary medical expenses not covered?
Yes. And actually, just a moment. I would say we would put a period after it says plan of insurance that's reasonable in cost and accessible. But I would stop and say we are not going to include the premium, or the premium, excuse me, including the premium, only the premium, but not co-payment or deductible. We don't know how often that will be incurred or what it is.
She's here.
And the payment of necessary medical, vision, and dental expenses.
So a period after premium is what you're looking at?
Yes. And I think it's only the premium. Under plan of insurance that is reasonable in cost and
that we thought
accessible,
anything other than
meaning the payment of the premium.
My recollection is it wasn't our intent to include unreimbursed medical expenses as part of the support obligation, but I could be wrong.
Correct. And so just by having it in the definition of medical support in this location and how it's going to fit into the big picture of our calculation, because we're moving it to the front end instead of a deviation, and it's not just extra language anymore, it causes that problem. that Ms. Baker's pointing out to us. But I don't know that we want, this gets into that bigger problem. When you get away from the deviations and you're trying to put it into the support calculation, but we don't necessarily want to lose the rest of that language somewhere, correct?
I think that we can talk about medical support language in two ways. We can talk about the fact that the medical insurance premium is built into the obligation for support, and then a second section which clearly states that the parents are responsible for sharing equally any unreimbursed medical expenses.
Keith Picker for the record. So if I understand correctly, the issue, we're talking about limiting this language to the insurance premiums only, and we're discussing how we deal with the copayment, deductibles, and any other expenses under a separate section. If I understand that correctly, I think that's where we were going when we were first talking about this.
I agree. I think that, this is Kathleen Baker for the record, I think that we just sort of got them mixed up and that we can just get back on track by dividing them and putting them in two separate sections.
Ms. Throne, are you following along with Ms. Baker so you can make those edits?
Yes, I have that.
Okay. Any additional edits that need to be made to this? All right, hearing none. Do we need a motion on that? We probably,
I'll make the motion to
yeah.
do those edits.
To be safe, let's do a motion. Do I have a second?
Hold on.
Hold on.
I'm sorry, Judge Hoskin again. I just want to make sure, okay, it does deal with in J, at the beginning, first sentence in J, medical support for the child. I just want to make sure that we're limiting it to the child, as I have many litigants that try and pass off half of their own healthcare expenses. Would it be overkill if in J1 we also include for the child, as long as we're making a definition?
D1?
Just so I don't.
Do you have a J on yours?
It's J starts regardless of the income of the payer. Is that what you have for C?
Mine says C at the beginning, but I'm following you.
Well,
I don't know why,
Maybe we
though.
ought to clarify that we're all looking at the same document.
Yeah, I'm concerned.
Medical support language revision at the top.
That's my one under J. Through I is the incarceration language you just looked at, and J starts regardless of the income level of the payer.
Oh, you know where? You know why? I think I know why. I think you're looking at the unified document. That's okay.
Yes.
You're looking at the unified
The
document that
proposed
Judge Rob
125B
put
is what
together,
we're looking
and
at.
we're looking at just the single sheet of medical support language, which had a different letter. Okay.
So are we all on the same page again?
Except for the change in the lettering at the beginning.
Okay.
Okay, all right.
It's the same
so we're all
language, so that's
together.
good. All right.
J talks about medical support for the child, and J1 doesn't say child. I could accept the fact that it doesn't because it actually says it in J, but would it create confusion, or is it overkill to put for the child in 1?
I'm in favor of overkill
So
because I
as
know
am I.
how it is in actual practice.
Kathleen
Yes.
Baker, so we would put down under, I'm looking at J1, which you're looking at, that it would be vision
Yes.
and dental under a plan of insurance that is reasonable in cost and accessible for the child.
No, I
The
think
cost
it
of
works
coverage, the
better.
cost of the,
This is Bridget Robb for the record. If it says coverage for medical, vision, and dental under a plan of insurance for the child that is reasonable in cost, doesn't that flow
There
a
it
little
is.
better?
Yes, it does.
I'm okay with that. Got it.
All
to
right,
turn
so
on my
for
mic.
purposes of amending the motion, I'm sorry, Keith Pickard for the record.
Go for it.
We would do, we're looking at adding the words for the child after, under a plan of insurance. We're adding a period after the payment of any premium and deleting the rest of the sentence. Is that correct?
We're moving the rest of the sentence. is my
Right, but for
understanding.
purposes of this language, we're deleting that from here.
Yes, from here it'll be deleted.
Well, that will be my motion then.
Second.
All in favor, say aye.
There's a question.
Oh,
I have a question.
we have a question.
Aye.
Judge Shirley has a question. Hold on.
I'm
Gonna
just
make you
wondering
revote.
if we ought to not put, are we going to define somewhere in the language that whenever we refer to child in the singular, that it could mean the children? Because if you have multiple children, it'd be an insurance plan covering the children, not just the child.
I'm trying to, okay, I'm going down to my basics. We do have statutes in Nevada. It says we're to interpret things gender neutrally, and I think that same language talks about pronouns and, or whether or not a word is plural or not. Do we need to do that? It's a good question.
Madam Chair?
Yes, sir. That would be a good
If we think
LCB
about,
question.
yeah, well, I think if we look at something like NRS 125.0035 sub 4, the best interest factors, it's all child. It's not children. So it's got to be there somewhere, but if not, it probably would make sense to include it in the regs.
In our definition of support, maybe? I don't know.
We're singular every place else in what we're proposing, we are singular. So if we're going to do, and I don't disagree with Judge Shirley, what I don't want is somebody to come in and say, no, you can only charge for one child because it just says child. Maybe within our definitional section we can include that same language you've just referenced if it's not covered somewhere else, that anything referenced in the singular can also be interpreted in the plural.
I would
Keith Pickard, for the
suggest
record,
that instead
I
of,
would suggest we do that very early, you know, in the first section of the regs that we end up adopting, because it should apply to everything we do.
yeah, I would say our end job is to give a report to Ledge Commission, which obviously, just because we wrote it doesn't mean LCB is not going to change it on us, for all of the conforming details needed. And because we're doing a report, we just put at the beginning of our report that we would like them to go through with the intent of making sure it covers child and children in however way they see fit. Because that's one of those things that LCB will get it right versus us trying to figure out exactly how to do that part. But I think it's a comment for the beginning of everything we're putting together, so. Okay, so the motion, Mr. Pickard, you want to add that to your motion? And we'll rerun the vote? I cut everybody off because
Certainly,
Judge Shirley had a
I'm
comment.
willing to make that amendment.
This is Kathleen Baker for the record, and I hate to be sort of a sticky wicket. I'm just wondering if we're looking at building the cost of the insurance premium into the obligation of support, why would we have the 5% limit of the gross monthly income of the parents? I'm looking at B, section B, where it talks about the case of payments for medical support. If it's built into the obligation of support, and the court has the authority to deviate based on the circumstances of the parents, I don't think we need to have the fact that the premium does not exceed 5% of the parent's gross monthly income.
Keith Pickard for the record. I think that, number one, we're trying to get away from deviations, so we want to make sure that we don't require deviations in those instances. It's in the statute currently, and it's a definition of reasonableness. I would suggest we keep that in there in order, number one, to be consistent, and number two, so that it becomes an addition in the calculation only if it is available at reasonable cost. That way, it's not a deviation if insurance is only available at more than 5%.
If, Ms. Cliff, I remember you testifying
Yes.
at some point about this issue and that you were worried that it stayed in there with the 5%, but I don't remember if there was a statutory reason or if it was or Miss Murray, maybe it was Miss Murray, it was one of the two of you had a very specific reason for that 5% mark. Am I wrong? Am I remembering wrong?
I think my thought was if we're developing this, I just didn't know how we were going to deal with the 5%. If, I think that was just more my concern is just to consider that section. But I think that was all I was thinking about.
Miss Throne, when you did your research, because we had you go cross-reference to other statutes when you put the medical language together, make sure we didn't miss from somewhere else. Did you find anything, is there somewhere else in our statutes that 5% is relevant or, borrowed from? Ms. Throne?
Yes, it is. It is borrowed from another statute, which I think is also still in play. But I don't remember the reason why they changed that limitation so that if somebody is paying $600 a month for one child insurance coverage, that the other parent may not be able to afford 50%, and the 5% cap is already in our statutory scheme.
It's in our current child support statutory scheme, but is it in some other? Miss Murray, are you on the phone still?
I am.
Do you know anything about where the 5% came from?
I think I do. So when you assess the determination that somebody has to pursue insurance, it can't be more than 5% of their income. So from there, I don't think I am not completely sure, but I don't think there's a 5% cap on what the people have to pay. It's a 5% cap on us forcing you to pursue it. If it's greater than that much of your income, then you aren't required to pursue that particular policy through your employer or whatever source.
Right, because it's part of the definition of what is reasonable in cost. And if it's more than 5%, that policy, right, because people will come in arguing you've got to pay for the, I'm going to be exaggerate here, but the $2,000 health insurance policy when that's 200% of your income, right?
Right. So
Okay.
I would assume you'd take that across to
So it's,
the next person. If the next person only makes $600 a month, you can't charge them 50% of that, because kind of by saying that you can't even buy it if it's greater than 5% of your income, how can you assume somebody else pay greater than 5% of their income to give you half of it?
okay, I feel better. Do you feel better, Ms. Baker?
I feel better. I think part of it's going to be helpful for me when we actually start looking about how we're building this obligation for support and how it is that we're going to build in the cost of the insurance premium.
Helps to have my mic on. I think your motion is now complete, Mr. Pickard. Am I accurate? And
I
we
don't
had-
think we made any changes after the last amendment.
I do
That's
not
correct.
agree. Yeah, I believe not. And we had a second, correct? I don't know who was your second.
Yes.
Okay.
Judge Rob was
Judge
second.
Rob or
but
Justice
she
Stiglitz
hasn't
are both
seconded
seconding.
the amended.
All right, all in favor say aye.
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 Those opposed say nay. Motion carries. Ms. Throne, you're going to make those changes and get them to Judge Rob for replacement into the primary document, please?
Yes.
Okay, thank you.
And I've been taking notes as well.
Okay, great. Let's,
Karen Cliff from the Clark
Yes.
County DAs, just for purposes of clarification, and maybe Don can shed some light. The 5%, I'm not sure if that statute is within an area that we can deal with, but I guess, Don, so are we going to have it in two places within the statute, standing on its own as it is now, and then also incorporated within this? Just for drafting purposes, I was curious.
Ms. Throne, can you answer that better? Since we did have you look, that's what we were worried about with moving it into the front end of the child support calculation. We were just, the bigger thing was that we matched where it was elsewhere, so I think we're fine because we're not deviating it from where it was in the other statute, or from what the language was in the other statute. Is that correct, Ms. Throne?
I think so, and it's always been in the since the first draft, that language has been in there, but it's 125B085 is where that is. So is that one of the ones that is repealed?
Yes. So there's our answer.
So we need
So we're
we need
okay.
to put it in ours.
Yes.
Thank you.
Okay, do we have any additional discussion on healthcare expenses before I close this agenda item? Hearing none, let's move on to 4F, discussion and recommendations as to how to develop and adopt a calculation for shared parenting time, serial parenting, and split parenting. And I know, Ms. Cliff, we tasked you with getting us some of the Wisconsin language on that. Would you like to talk to us about that?
Karen Cliff. Did everyone get a chance to look at some of the different examples? I'm just doing a.
This
mentally
is
looking
Kathleen
at-
Baker, and I did take a look at the examples.
Does everybody, let's do this. Let's give everybody a chance to look really quick, because I know this committee at this point. We're so overburdened. Go ahead and take a moment and take a look at the Wisconsin information on those topics.
I would also like to add the brief that I think Don provided us with provides a lot of guidance in terms of what the family law section is leaning towards, and hopefully we can get to discussing that today as well. This is Karen, not to shift the burden, and especially I know everyone's reading. In terms of this particular area, I just have to say from the 4D program, this is one situation I will defer to my colleagues who obviously see this situation much more. In terms of our program, I don't see these scenarios too often. So while I'm happy to provide any of Wisconsin's information, I don't have a position.
Okay.
Maybe as this evolves organically, I might have a position, but I'll defer to the committee.
Okay, thank you. Ms. Baker?
Kathleen Baker for the record. With respect to the split case scenario, I do have some concerns about it. I read the brief. I understand the basis and the thought process, and I know that's how it's being done, often taking, if it's two children and one is primarily with one parent, taking 18% from 25%. But that works really well if you have a high-income earners. I have had a number of these cases, and the most recent one I had was on January 9th. And the concern that I have is that the parent who had full custody of one child and had the other child 50% of the time didn't even get 18% paid to her. She didn't even get enough for one child. She actually got less money when she had one child full-time and the other one part-time. And the way that worked is that the parent who had one child half-time had a gross monthly income of $2,562. 18% of that was $461. The custodial parent made $1,906. 18% was $343. So 25% for the non-custodial parent was $640 minus $343, left the custodial parent with $297, when she at least should have had $461. It seems to me that if you have one child full-time and another child part-time, you should get more than the amount for one child.
Additional comments from the committee? I will I'll add a comment. Obviously, from the brief from the family law section, from a private perspective, this is our ongoing chaotic debate. I'd say this is one, and do we calculate each hour of the day? Where does the kid's head lie? How do we figure out time splits, et cetera? It's an ongoing problem for us. From a private perspective and the position that the private bar took, I would have just carte blanche gone with it, except for hearing Ms. Baker's representation that at high income it seems to make sense, at low income it may not make sense. And that's our ongoing problem, right? Then I don't think that you take on a different analysis. I don't think we have two different calculations in this scenario. That doesn't make any sense. But maybe there's a minimum threshold, meaning, like you're saying, your parent ended up, had she had primary custody of both kids, turn your mic on, please.
Yeah, if she'd had primary custody of both children, then she would have received $640. If she, and if there'd only been one child involved, she would have had at least $343. This way, she ended up with $297. With one child full-time and another child half-time.
With 1.5 children, which that sounds terrible, but yeah. Wow, when you say it out loud, it's, I had 1.5 children, split the baby. Maybe it's adjusting it to have a minimum threshold. And I don't know what that means, but you.
Kathleen Baker again. I think part of it has to do with the disparity of the income between the parties. So in this particular instance, there was not a huge disparity in their income. The scenarios that I saw, well, in one of them in the brief, there was a huge disparity in the income between the parties. And the other one, not so much. But I think in the second scenario that was in the brief, that parent was getting less than 18% that she would get for one child. So I think that that's my concern. We can't leave any parent with less money than they would get for one child when they're taking care of one child full-time and the other one half-time. And the Wisconsin statute, I played with that, and the numbers that I used, the same sort of thing came out. It wasn't quite as big a difference, but it was still less than what you would get if you only had one child for the split custody scenario.
This is Bridget Robb. Couldn't we make 18% the floor?
I think we could make 18% the floor, but then that would be for the one child. But then the question is, how do we calculate out for the second child? And I've looked at a number of different scenarios. One of them that I looked at is that the difference between 18% and 25% is 7. So do you take 7% of each party's income and then do an offset on that?
No, what I was suggesting, Ms. Baker, is that we run the calculations the way that's been proposed, but just say in no event can that amount be less than the 18%.
It's almost like our caps, the reverse of our prior caps.
And
exactly. We have a floor.
Well, we have a floor, but then what do we do about the cost of that second child being with the parent half-time? Do we say, well, you don't get any extra money for that?
Yeah, but you don't have to pay any extra money the other way. It's kind of a wash.
But they wouldn't pay any money the other way.
Right, so that is a wash. If they have relatively the same income.
As I understood it, Ms. Baker, was that your custodial parent was getting less because of the second child than what she would have gotten had she just had one. If we make the 18% the floor, we eliminate that issue. There won't be payments made for the joint custody of the second child either way.
So this is Kathleen Baker. Are you suggesting then that if, in that type of a situation, that with respect to the shared custody of the second child, that neither parent owes the other anything for that second child?
That's my suggestion.
And then I
That
guess,
in a circumstance where the custodial parent of, to use Ms. Surratt's language, the 1.5 custody parent, if that parent is going to be getting less than what they would have gotten having just one, then we call it a wash, and the 18% is the floor. So neither parent is going to pay anything because the party who would be doing the paying would be the custodial parent.
well, that's not my scenario. My scenario does not have the custodial parent paying money.
Yes, it does.
If you assessed each child separately at 18%, because the custodial parent of the one child is making less money than the non-custodial of that parent, the custodial parent would be getting money for both children, would not be paying the non-custodial parent in this scenario.
Except that she in effect is paying because she's paying out of the 18% that she would be getting otherwise. What I'm saying is let's seal it at 18% so we don't go below that.
I agree we shouldn't go below it. I guess what I'm thinking is we should be going above it if she is also caring for a second child part of the time. So she is, in essence, gets what we determine to be an appropriate obligation of support for one child, with which she then supports one child full-time and another child half-time.
And she's not having to make any offset or make any payment to the other parent for the half time that parent is supporting the child.
And if you looked at an offset on the two incomes, she still wouldn't.
I'm going to hold you guys off for just 2 seconds here. We're going to relieve Justice Stiglitz because this brief is pending in front of the court, the Supreme Court, and we're going to get her out of here. Thank you, Justice. All right, now you can continue your conversation. Thank you.
The only suggestion I have is this isn't a case that is replicated daily. This is going to be the exception, not the rule. So again, why don't we spend our time on the rule, and we can take a look at the exceptions, but I think we've spent an awful lot of time on this. There's a suggestion on the floor. If anybody has another suggestion, make it.
Karen Cliff, Clark County DAs. I like where Judge Rob is going on this. This is good math. Easy math. I mean, it's fair, but it's also good math.
And Judge Hoskin, if I can weigh in here, I'm not happy with Wisconsin just from the sheer volume and the confusion that I end up with it at the end. And I was going to suggest that since it's my case and Justice Stiglitz is hearing it, that we don't talk specifically about the Miller case, but it's too late. She's already gone. But I'm
Talk about Kathleen's case. That's what we're talking about. Kathleen Baker's case.
And which is the problem is it's not too dissimilar from the facts of the case that's pending.
Yeah.
Except for the fact that the judge was smarter and didn't go that low. So with regard to how to approach this, I think there has to be a simpler way. While I did steal from Wisconsin for the gross income, and I thought it was too long, it did kind of fit in with the discussions that we'd had to that point in time. But this is more than I think a pro-per can wrap their head around, which makes it too difficult. And this is really the only proposal we have so far with regard to this scenario. So this is the first time I've seen it. I mean, I know how I run it. The problem is when I run it, I run formulas and I compare formulas, and then when I get to the bottom line, I do what Ms. Baker is indicating and saying, well, wait a minute, that doesn't make any sense, and then adjust it accordingly. And I'm still of the opinion that at some point the Supreme Court will tell us what they think about this, or they'll simply remand it to me and say follow the law, and I'll have nothing to do. So I'm not happy with Wisconsin just for the mere volume and the confusion. I think there's probably a simpler way of doing it. I'm not opposed to a low cap for these kinds of scenarios, but The problem we're going to run into is we'll never cover every scenario that will be presented to the court. And then you may want to leave it to discretion of the court with certain guidelines to get us to that point. But I agree, if you're running high and low, and I've done it, I've run high on obligor and high on obligee and tried to make those calculations and come up with resolutions that I think are reasonable. But as I've been told several times, there's a lot of other judges that don't do it the way that I do it, and I just assume that everybody does it my way. I don't even know why I'm telling you that.
Kathleen Baker for the record, and while we may not, I mean, if we end up with at least we have 18%, I think that certainly would be helpful. I'd like to switch over to the serial parenting. I did look at the table, the attachment they had. It was kind of interesting that the language in the statute, I agree with Judge Hoskins, it's just too complicated. It was very hard for me to decipher it. But when I went to the table, one of the things they did with the serial parenting that I thought was kind of interesting is they took the child that was first assessed a child support obligation, and for the sake just of illustration, let's say the non-custodial parent earned $2,000 and was assessed 18% of that, and we'll just, because I'm not going to do my math, we'll just say it's $200. So then he has a second child, and at that point, what they said is now his income for the purposes of computing child support for the second child is only $1,800 because there's this payment of $200, so that income's no longer part of his income. And then they just went down the way. It's not the ideal, but it certainly gave some guidance to how do you deal with this so that the non-custodial parent is not paying 55% of their gross monthly income when they're making $2,000 because they keep having babies.
Yeah, it's coming to me, huh? That darn camera. Although we switched, we've got all this under one agenda item, of course, which probably isn't fair to have shared parenting time, serial parenting, and split parenting all under one agenda item, obviously. But I do want to take us back to the shared parenting for a second, because I feel like we were getting a little bit of momentum with split parenting. Jeez, goodness, Kim. Split parenting. And I feel like we were getting a little bit of momentum with it. I was liking having the floor on that. I agree that a lot of the Wisconsin stuff gets heavy. I mean, it got to the point I didn't hardly want to read it because there's so much to it and too confusing for me to judge, which is not the goal of this committee. The goal of this committee is to really try to aid the public also, that it's not just attorneys that are going to be calculating child support. But do we have any gut or feeling about maybe doing a motion about the split parenting calculation? Silence. I love the crickets. If not, we'll move on.
I hate even mentioning this because I'm assuming it'll come back my direction, but I think that it's possible to take what Wisconsin has done and simplify it, and put it in terms that would be a little easier to understand. So I nominate the chair to go ahead and take a stab at that.
You are daring, my dear man.
Madam Chair,
Understanding fully that you have the power to do whatever you want with this stuff, so.
If I could just add to that, he actually
You're volunteering?
off mic nominated me to do that, and I reminded him that he has heard me make an argument. I cannot simplify anything.
Well, I would agree with that. Don't push me.
Madam Chair,
Yes.
This is Judge Robb for the record. You have given me grace and not made me do homework for a while, save and except trying to pull everything together into one document. I would be willing to take a whack at making this simpler.
Thank you, Your Honor. I appreciate that. And I'm almost willing to make it a motion, but I don't think we need a motion for homework, so. Thank you. So with that said, and that is going to be on the split parenting, split custody.
So do we have any additional conversation? Let's talk about serial parenting a little bit more, because Ms. Baker did go into that, and we have not received other comments from the committee on that. I'll throw out there that before a couple of days ago, one of my colleagues in my office came to me with a scenario with a parent with serial parenting, where he started with his gross monthly income at $2,474, and by the time we got done, he was going to net in his pocket $180. Again, this goes back to the you kept having kids. I get it, but obviously we're silent in Nevada if we don't add in some language on this issue. And I think everybody struggles with what to do with it. But do we have additional comments from the committee on this topic?
Madam Chair, this is Bridget Robb again, for the record. The thing I don't like about some of this is the race to the courthouse. The person who gets there first gets the most for their child. And there is just something inherently wrong to me when one child gets treated better than the rest of the children simply because of when they got their judicial determination. It isn't even this is the first child. It could be the third child and there hasn't been a child support award yet. So that troubles me. I don't know how to fix it, but that troubles me.
I agree. Additional comments?
This is Dawn Throne.
Yes, Don?
In looking at it not from the side of personal responsibility and you shouldn't keep having children you can't afford, but looking at it in terms of getting the right size order, what seems to make sense on serial parenting is let's take your example, $2,474 gross monthly income. They have 5 children by 5 different moms or fathers, whichever you want to put there. But take the total amount of child support for 5 children, 8, 16, 42, divide that by the 5 children and split that up. So they're not paying more of their income than a percentage if they had all 5 children with one person.
This Judge Hoskin, this to me falls into a very similar categories to the conversation we were having with regard to incarcerated parents. And we're spending so much time focusing on the obligor, we're losing sight of the child, which I think is part of our mandate to make sure that there's child support. So a child is being punished because their parent keeps having other children. I'm with Judge Robb. I don't know how to solve some of these problems, but it's distasteful in my mind that we're going to that step. Certainly, you're not going to enter an order that leaves somebody with $100 net a month, but there has to be some balance between the ability to pay and the needs of the child in the totality of what it is that we're doing.
Keith Pickard for the record. I guess because everybody's definition of net can be different. I'm assuming we're talking about net of reasonable and necessary expenses. And if a party comes in having, produced numerous children, and we are looking at the net after all the reasonable and necessary expenses, I don't mind leaving him with $100. I don't mind leaving him with nothing. Because ultimately, again, coming back to the policy, we believe that it is incumbent upon every parent to support every child they have. And so maybe I'm missing the definition of net, but if it's net of all of the deductions and the reasonable and necessaries, I'm perfectly okay with leaving them next to nothing if the kids get something out of that.
Yeah, but my scenario wasn't that. The only net it was netting after was federal income tax, Medicare, Social Security, the have-to deductions. So that goes back to what the feds are telling us, which is you can have that attitude and we can take that perspective, but then you're more likely to collect nothing off of that parent, and then nobody gets anything because your enforcement goes down dramatically because you didn't have a right-sized order, or one of your orders might have been right sized, but not all of them. So probably the subsequent ones are the ones to not receive any assistance. So again, we're back to not helping the children if we can't enforce. Ms. Baker?
Kathleen Baker for the record. So the other thing is that our percentages are based on gross monthly income, and at least in the 4D arena that I'm in, expenses aren't considered when making the child support orders. They are based solely on whatever the person's gross monthly income is, regardless of what their other expenses are. There's sometimes a deviation because you have the obligation to support another child, but it doesn't take into consideration whether you have a roof over your head or food or anything else, like paying your probation costs so that you can stay out of jail and keep working.
I'm sorry, Keith Pickard for the record. I'm sorry. I honestly, I was thinking alimony when I was thinking of net disposable. So I'll take back everything I said. Strike it.
I had to hit my mic
Karen.
button so I could laugh out loud. Go ahead, Karen.
Karen Cliff from the DA's office. Just curious, because my brain is fried after doing this for a while. Not today, just in general. Are we adopting an appendix for low-income payers? I can't remember if we discussed doing
Yes,
an appendix.
and Judge Rob's comment was it just didn't get attached to the cumulative document that we've got running.
Okay, so
So it does need to go
That's-
into our cumulative document so we don't forget about it. It has been discussed
okay.
and
So
voted
our
on.
appendix it deals with having multiple children, correct? Like the appendix that Wisconsin uses, 1 child, 2 children, and it's kind of that grid. You make this, and you've got 4 children. You're here. If so, does that change this conversation at all?
The Wisconsin one did originally, did ours that we ultimately, ours was what was developed by Ms. Crecilius for us. It had, 1, 2, 3 children, right? And it changed on those numbers. So on the low income level, it did cover that. Yes.
So on the low-income level, it covers when you have more than 1 child, but it presumes it's with one other parent. So it still doesn't address the serial parenting issue.
Well, and of course, we all know where the trouble comes is different courts, even different cities sometimes for those child support obligations. I wonder if we can modify that chart, though. I mean,
That's what we were
yeah,
thinking.
so that it
That's
can
what I'm
work that way.
thinking.
Yeah. My brain's working hard now, too. Because it still brings you to reasonable numbers. The problem still becomes, do you take that 5-child child support amount and divide it by 5? If you have 5 different other parents? Then you get a really small child support amount. But you have children being treated equally. And of course, a bunch of us don't have this chart in front of you, do you?
We're all looking at Dawn right now.
Because she's the organized one. Well, Kathleen's got hers, and that's where I'm looking. I want to break it into something simple to start with. I want to make a motion that we at least start with adopting the definitions of what a serial parent is, a shared placement, and split parenting, because from Wisconsin, because they had really good definitions for that. And I think if we at least start with that language, that's something more than Nevada has right now at all.
Second.
Okay, second. All in favor say aye.
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 Those opposed say nay. Motion passes. And we have that language that was it was separated out. It was Wisconsin Administrative Code DCF 150.02. It'll have to be modified a teeny bit just because just to fit with us what we're doing. But I will provide that specific language to you, Judge Rob, for incorporating into our main document.
Thank you.
Okay, that'll get us one little tiny step forward. The next is, to clarify from what we already decided, Judge Robb is going to take the split parenting language from Wisconsin and try to simplify it into some kind of formula we can use in Nevada. That leaves us with serial parenting and shared parenting. Serial parenting, I wonder if we can do the same thing with Wisconsin's approach to serial parenting and simplify it, / using the chart in some way to deal with more than one child. Thoughts on that?
It was my understanding that Judge Robb was going to do all three. That's how I understood your assignment to her.
It might failed and say, personally, do we have a problem with our methodology in Nevada for shared parenting time when it's not serial parenting? For shared parenting, child support.
I don't believe so. I think we've got case law that gives us some real clear guidance that we could certainly codify.
Purely a codification issue, in my opinion.
I agree.
Do we have other thoughts? What was that, Judge Robb?
I said, I think you're right, and by the way, I'm happy to take a run and make all three less daunting.
Yay, done. All right.
Sorry, Judge.
So to summarize,
Well,
Judge,
I'll get my own.
I'm going to get you those definitions to incorporate, and you're going to work on codifying Nevada's current statutes, or not statutes, I take that back, more case law for shared parenting, and take a approach of simplifying serial parenting and split parenting from the Wisconsin model to come up with our own hybrid approach for it. Okay. I am going to, unless there's additional comments at this moment on 4F, I'm going to close that agenda item. And the other thing I'm going to do is have us take a quick 5-minute break and come back, and then we'll start another agenda item. All right? See everybody in 5 minutes. Okay, team, it has been 5 minutes. Do we have everybody back? 1, 2, 3, 4, 5. Yep. All right. I closed agenda item number 4F. Shall we take a crack at the definition of gross income that was put forth and the changes that were made on that? And that will fall under agenda item number 4I. 4I, sorry. I was lost on my agenda for a second. Discussion and recommendations regarding definition of income for calculation of child support. Judge Hoskin, do you want to take a crack at this?
Sure. I was tasked with this, Assemblyman Pickard, I think, jumped in on board. I can't remember if he voluntold me or how that happened, but essentially what I did was I went to Wisconsin and plagiarized quite a bit of theirs. Assemblyman Pickard and I had a meeting and discussed making some changes based upon conversations we had at the last meeting and try to incorporate that in. I did have an email exchange with Ms. Cliff with regard to that and other statutes that define income. And based upon that, and I sent it off to Judge Robb before I had the conversation with Ms. Cliff, but I'm suggesting that we clarify that gross income for purposes of calculating child support means, and then go on from there, so there's no question as to whether we're stepping on some other statute with regard to income. But what we've tried to do is incorporate using what Wisconsin has done, as well as some changes that Assemblyman Pickard and I put together, as well as what is not child support, and that's subsection 11 of that proposal. So I think it's pretty inclusive, but I have no pride in authorship because I stole it. So I'm happy to entertain any discussion with regard to additions or deletions or changes.
Okay, I wanted to clarify. You stated that based on the language that was in the document from Judge Robb, we should still modify it where at the beginning, right after B, it says gross income means, we really should say gross income for the purpose of calculating child support means all of the following, correct? Is that?
That is my suggestion,
Okay.
yes.
Okay. Other comments from the committee? Does everybody need a moment to read it? Go for it. All right, we'll come back in a second when after I give you a moment to read it. Yep, go ahead.
This is Ellen. Under section 11E, it says food stamps. The program's no longer called food stamps, so I don't know if we need to update that language. It's Supplemental Nutrition Assistance Program.
What's it called?
Supplemental Nutrition Assistance Program, SNAP. Supplemental
Okay.
nutrition assistance program.
Great. Additional
Is it-
oh, go
Should
ahead.
I'm just making edits for it. Is it known as SNAP? Should I put in parens SNAP?
Yes, it's commonly known as SNAP.
Okay, thank you.
Additional comments? My comment would be congratulations on getting some neutral ground going on this after our last meeting. I'm good with
Ms.
what's
Cliff
in
and I
here.
came to an understanding. It's all good.
Ms. Cliff, I would like to hear your opinion on this, though, still.
I have motion to approve. This is great. Thank you.
There you go. Second?
But
We'll do
this is
comments
Dawn
still.
Crone.
Okay.
We do have at least one other kind of income that is missing here, and that's retirement income. If you're retired, you should definitely be paying child support if you have little kids.
Under 3, should we stick it
3, that'll work.
I did not hear that. Whatever you guys just said was, your mic was not on.
I said, should we put it under 3 if we're in agreement that it should go in? I'm just trying to find a place to put it, or enter a new number. Assemblyman Pickard suggesting a new number between 3 and 4, 3.5 is what I'm going to call it. Then the question is the language to put in, retirement, including pensions, other words?
You have to be careful with that because there's so many variations of them. It'd be really
Yeah.
easy to, if you go specific, miss something. If broad might be better, unless
So
it's examples,
any-
including but not limited to.
Retirement
Because
income
annuities,
including but not limited?
IRA, yeah, I mean, pensions. So I mean, there's a bunch that could be.
Is there a concern other than just putting retirement income? Is that going to get us in trouble on this? We're fairly
I think it's safe.
brief on the rest of it, on the other definitions.
It's meant to be broad.
Yeah? Can anybody think of a reason why that would cause a problem?
I'm not hearing anything. Anything in Vegas?
Okay.
No? Okay.
Okay.
On the phone too? Okay.
So, Ms. Cliff, were you willing to accept that amendment as part of your motion?
Yes. Thank you.
And the SNAP amendment too, Ms. Cliff too?
Yes, please, with this SNAP amendment.
Okay. Do we have a second?
Kathleen Baker, I'll
I'll
second.
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 Okay, Ms. Baker seconded. All in favor say aye.
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 Those opposed say nay. Motion passes.
All right, I will make those changes and forward it to Judge Rob for compiling.
Okay. Beautiful.
Thank you, Your Honor.
I think, let's discuss 4G, discussion and recommendations regarding revised proposed language for calculation of child support with child care expenses. I left this on here, but I could not remember from the last meeting. Did we have any additional changes that were made into the main document for child care, or is it still the same? Judge Rob, do you know?
There, to the best of my knowledge, there were no additions made with regard to childcare.
Yeah, I believe we're done, and I need to take that off the agenda. I just got nervous and wanted to check, because with all the different amendments coming in at different times from different people, I could not remember that, so.
Well,
Cam?
and it's
Yes.
possible, I'm sorry, it's possible that it was left on there because we're still waiting to get all of those totals before we can go back and adjust that with the child support calculation, because we're including that as
Right.
part of it. Maybe that's why it was left on.
I think
we
so,
wanna
because we
leave it
didn't
off
have
for
it
that
quite
purposes?
incorporated into the main document
Yes.
yet. And
Yeah.
I think realistically, once everything is in the main document's going to be on the agenda for review, but it's specific for the public at that point, because we'll have a document we're pointing to that we're reviewing. So as far as the agenda goes in the future, it's not going to disappear as long as it's part of our main document. And I think, Judge Rob, were you about to say something? Or
I
no?
was not, thank you.
No, okay.
Hey, Kim,
Oh, it was
this is not,
Miss Murray, okay.
so
So at I think the very last meeting, I tasked my staff with looking at how other states are handling childcare that have similar models to ours. And I actually received that information and did not get that out to the committee. A basic statement is they use it as a deviation, and they don't have it in there, but I have some good documentation that I'll make sure to get out to the committee as soon as possible, and I'll get it on the site for everybody to look at.
Okay, thank you. So for the future agenda item on that, for 4G, I will just make it that we're going to review any information provided by you if there's any discussion amongst the committee members about it. Okay? And looking at the time on the clock, I think for now we are going to go ahead and skip down and discuss agenda item number 5, discuss and approve ideas for future agenda items. Obviously, it's been mutating based on our conversations, but is there anything that we have not discussed or hasn't been showing up on the agenda that anybody would like me to add for one of our future meetings?
Judge Hoskin jumping in again, and I don't recall if this was assigned out previously, but we've received a lot of different information with regard to cost of raising children and those kinds of scenarios, and I think that's the number we need to be looking towards. I know we got a colored breakdown last time, so perhaps an assignment to the entire committee to do some math with regard to the numbers that we're dealing with and the inclusion of the 5% on the healthcare costs as well as the child care costs, so that we can be in a better position at the next meeting to decide where we are with regard to those calculations and those percentages.
Yes, sir, I agree. Any additional items?
At some point, I'd like to get back to the idea that the parents can have some say in what their obligations are going to be, so their self-determination, providing there's no duress and the needs of the child are being met.
We had listed that as stipulated orders. Is that okay language for agenda item for you?
Yes.
Okay. I had removed from the agenda, it doesn't mean it's gone forever. I had removed that item just because I wanted us to get some of the hardcore topics done first. But we had also had not quite finalized language on emancipation issues and self-adjusting orders. At some point, I'll probably entertain putting that back on the agenda. I wanted us to get to the point where we had our actual child support calculations before we got back into those weeds. We do have on the agenda that we did not cover today, discussion and recommendations on proposed language for guidelines on income imputation. That was 4D. We discussed,
Kathleen Baker,
yeah.
for the record, I thought we had agreed at the last meeting that we were going to adopt the language as it's set out in the regs.
We did, and then did that make it in here, though? Now that I go back to that item. Yeah, we had discussed the extent of us dealing with the imputation language was just to, the regs had that very specific language about when you can and cannot impute income. And that did not make it in anywhere, and I don't know that we and part of that problem may have been it didn't really get assigned out as a task, I think. And so I will take that on because I know where it is in the regs. So 4D, I will very specifically put on here, Kim, provide language to Judge Robb. The other item we did not discuss today was 4E, discussion and recommendations as to how to develop and adopt an adjustment for additional dependents. And that's also That kind of falls in 4F.
I was going to say, isn't that a serial parenting kind of idea?
I think it is. And
Well,
well-
maybe not entirely. It's, in my mind, that's the deviation factor for support of other children outside of even when there might not be a child support obligation. You've got other children that are residing in your home.
Or
but there's no
elderly
support
parents you're
obligation
supporting.
attached to, yeah. So I think that's kind of a carryover from our deviation, what we're now calling adjustments.
Okay, well, while we are at, oh goodness. Do we have any other discussion on it from that perspective? Do I need to redefine that agenda item? Or just leave it as additional dependents and we'll look at it at another
works.
meeting?
And maybe if you put additional dependents without support, without a support obligation, so that we're getting old in our committee, I guess, and we're forgetting some things, but that may make it a little easier next time.
Okay. So we'll keep that on the agenda. And then the other agenda item that I think we need to talk about, we had been talking generically about deviation factors. We had made some modifications in here, but I don't know that we had a good, solid decision on how to deal with, for example, community property income from your spouse and its impact on the child support calculation. Am I far-fetched from saying that should be a future agenda item?
Keith Picker for the record. I think we probably should have the discussion. I think that that would more reasonably fall to a true deviate or adjustment factor. But at the end of the day, I do think that it's relevant. And so I think we should have the discussion.
Okay. Are there other deviation factors that kind of fell off when we made our changes from our current Nevada statute, not from the Wisconsin information, that need to be brought back in as agenda items?
We're just trying to run through all the deviation factors down here, so it's not, we're not
Correct,
ignoring
we are
you. We're-
too, sorry. And by the way, the deviation factor in F describes what we were just talking about, additional dependents without support obligations. In the language in here, it does say the legal responsibility of the parents for the support of others, but that's still legal responsibility, so we kind of need to cross over that, I guess, to both. The rest of these, my personal opinion is the rest of these are fine as deviation factors versus creating new agenda items for us to go in depth about. Is that a fair statement?
Kathleen Baker for the record. I think there might be a good idea to clarify the deviation or how we're going to deal with when the child gets Social Security benefits that are independent to the child and not resulting from the parent who's responsible for paying the support.
I thought that was already in the language.
Well, is Social Security benefits going to be, and I guess it comes up especially in cases where you have a handicapped child that support continues past the age of majority, and that child may be independently entitled and receiving Social Security disability benefits. And so is there still an obligation to support? Yes. Do those Social Security benefits that go to the child, are they used to offset the amount of support that the parent might be required to pay?
This is Karen from the Clark County DA's. When we do motions regarding support for a child beyond the age of majority, it's a factor that's considered. We look at the statute and we look at the petitioner's various medical bills, the cost to raise a child, the SSI the child may be receiving, the cost of a full-time caregiver. all of those things. So all of those things come into play in terms of assessing the child support obligation, if that helps at all.
This may be an issue that it doesn't need to be discussed. I know it has been an issue that's come up and been dealt with in different ways in my jurisdiction.
We did incorporate a little bit of Social Security language into the gross income definition, and then there's the language and the deviation factor at the end. But if you feel like we need to maybe look at that in more depth, I can add it as an agenda item. I have ability to modify the agenda. So maybe next time we'll discuss, when we discuss future agenda items, again, be prepared to maybe decide if we really need to add that at a future meting.
Kathleen Baker again. I'd like to really see us focus on the big pieces. I think that's something that may need to be addressed, but it may be smaller, and it may be something that we can look at later on.
Okay, any additional agenda items for right now? Okay, close agenda item number 5, hearing none. Number 6 on our agenda is discuss and approve future meeting dates. We have dates already set forth, but just for clarity on the record, our next meeting date, I've got Joy on the hook here. She's looking really fast. March 9th, okay? And Joy, are we still clean on using the legislative buildings right now? Okay. So as of right now, they will be at the current locations that we're in right now. Whether or not they're in the same hearing rooms will be determined. Watch your agenda for that. And we will close that agenda item. Let's move on to public comment. Do we, again, as it was at the beginning, everybody's limited to 3 minutes in public comment. I will cut you off and unfortunately be rude, but we treat everybody fairly. Is there anybody in Las Vegas at this time that would like to give public comment?
Yes, I'd like.
Are you in Las Vegas? We're doing people who are currently in Las Vegas first, in person in the
There's no
hearing.
one at the table.
Nobody in the room or at the table? Okay. On the phone, do we have anybody on the phone that would like to give public comment?
Yes.
Okay, go ahead, sir. Announce your name first, please, and you have 3 minutes.
Alexander Falcone, Alexander Falconi, Bar Nevada Judges. I just wanted to comment on the child support imputation. There was a little bit of discussion on that. I didn't know if it'd be useful, but I know that Mini-R v. Mini-R talks about how if somebody's willfully underemployed, and it kind of just stops there. I noticed a case in Arizona that might be helpful. It's called Little v. Little, and they sort of carry the ball onto what constitutes for the purposes of avoiding child support. They have 3 different standards, one strict, one that they call good faith, and one right in the middle. It might be useful. I don't know if anybody here knows about that. And they also cover little details such as, parents who just can't work, such as someone who's in jail versus the parent who can work but doesn't want to and wants to, go on a vacation somewhere and experience life. I mean, they try to draw a line where they're willfully underemployed for the purposes of avoiding child support. Also, they talk about something that's interesting, and they mention that if a parent who's going to willfully be underemployed for the purposes of avoiding child support is losing 82 cents for every 18 cents they deprive their adversary of, and usually that comes down to like severely vindictive or spiteful personality disordered parents. Most people don't want to lose 82 cents for every 18 cents they deprive their opponent of, at least not for a long time, maybe initially. And I did hear some stuff on serial parenting and how a serial parent could be deprived of all of their funds. As the ratio goes higher to higher, the motive for that parent to just check out and not provide any income at all gets higher and higher, and it sort of bleeds into just, the regular person just saying, I'm just not going to pay anything, I'm done, I don't care if I go to jail. And then there was some discussion on the minimum child support amounts. There's something about filing a motion to have the court hear the issue versus just automatically adjusting it. Just in my experience, a lot of pro se litigants are terrified of filing anything. And a lot of that comes from sanctioned motions and having been sanctioned. So I'm not sure that that's actually anything that you can consider in altering the way you're going to deal with that. But just I think that I think people here maybe cognitively understand the fear that a proper first litigant may have in bringing issues to the court, but the emotional fear, the emotional connection to that cognitive understanding isn't there. And with a lot of them, it's terrifying. So I realize this example is not very good because prisoners don't seem to be afraid of filing anything, but just people that aren't in jail, it's just a different situation. Hopefully this information is useful. I have no further comment.
All right, thank you. Is there anybody else on the phone that would like to give public comment at this time?
Yes, I would.
Okay, sir. Announce your name first, and then you'll have 3 minutes.
Hello, my name is Michael McDonald. I'm FCLU, Veterans in Politics, Reforming Family Courts. I would like to make a couple of comments on what was discussed in today's meeting in regards to a couple of the issues there. For one, the jail amount set to zero. I would definitely say that you guys should automatically set that to zero as soon as a person gets incarcerated. I'd also suggest that there be studies into the effects of what the TPO laws and the amounts of parents that are getting incarcerated because of orders that are unfollowable or orders that are put in place where they're pitted to try to see their own children. They're getting thrown in jail. And one thing too is I noted that the DA's office and the child support court do not communicate at all. So I'd like to suggest that you guys suggest some kind of committee or some kind of process where they do correspond and they'll give that information over to the DA so they don't go after them in the enforcement side. So and that's another thing too. I mean the enforcement is so it's so harsh sometimes to take the licenses away and throw people in jail and things like that, where they're pitting their parents that are running away from the law. They're running against their obligations because they're so afraid to getting incarcerated or getting their licenses taken away. So I really suggest that you guys look into that and see what the effect, whatever you guys put in these laws, one little word can affect so many lives. So I want you guys to know that your responsibility, and commend you guys for going and being thorough on this, because this is affecting millions of people and all of our citizens here in Nevada. As for health care, I would suggest that you guys allow both parents to suggest what plans and whatnot. I've had instances where you have parents that go and get the platinum plan, the highest plan you can get in order for their children, and it's outrageous amounts. I mean, I would even suggest, like, I know you guys were talking about the income requirements. Well, here's an example. Let's say a person makes about the average income about $3,600 a month. They have 2 kids. Times that by 25% of their income. It's $900 a month. Then I calculate on top of that half of child support, daycare, so about $600 a month. And then medical, half of medical is about $364. That's about $1,800 a month. That's more than 50%. And then how is that parent? The majority, it's a lot of dads and mothers these days, and it's over 50% of their income. How are they supposed to live? You're punishing one parent for putting the other parent as a debtor to enslaving them. So I'd like you guys to do some research on that as well. So the effects of child support on the actual children, like where's the money being spent? I know there's a new card that's in place for Chase, and I'd suggest that you guys put on that card that both parents have access to, that can actually see where their money's being.
We appreciate. It's been 3 minutes, Mr. McDonald. Thank you. Appreciate your time.
Sorry, it's hard to get all of it out in 3 minutes. There's a bunch of good comments. So thank you.
No worries. And Mr. McDonald, I want to encourage you to keep in mind the purview of this committee, because we can't change federal statutes. We can't change policies and procedures between the DA's office and the court. We are strictly 100% in Nevada, the calculation of child support. And you can take a look at the materials online at AB 278 to see the purview of what it is we can deal with, and the legislature hasn't given us additional authority beyond that. Are there additional individuals on the phone that would like to give public comment at this time? Hearing none, I would take a motion to adjourn.
So moved.
Seconded.
All in favor? Aye.
Aye.
Anybody opposed?
Aye.
All right, thank you.